Hi friends, in this video we are going to deal with the important and latest Supreme Court judgments pronounced now in the area of property, labor and criminal laws. To know more about them, please watch the video fully. The important judgment, which is titled BHADAR RAM through legal representatives versus JASSA RAM and others, and pronounced on 5th January 2022, deals with that a person belonging to scheduled caste or scheduled tribe in relation to his original state of which he is permanent or an ordinary resident cannot be deemed to be so in relation to any other state on his migration to that state. The facts of the case would be that the dispute is with respect to the land situated at Dharam Singh village in Sri Ganganagar district, Rajasthan. The said land was allotted to one Chandra Lal as scheduled caste landless person and father of the respondent herein, the original plaintiff. As per the case of the respondent, the original plaintiff, in the year 1972, the said Chandra Lal borrowed a sum of rupees 5,000 from one Puran Singh, and under the guise of documentation, the said Puran Singh belonging to high caste fraudulently made Chandra Lal sign the sale deed in favor of the appellant herein, the original defendant BHADAR RAM, who was a resident of Punjab. The said Chandra Lal filed a suit for ejectment against Puran Singh and BHADAR RAM on the ground that he was the allottee of the land and disputed sale deed is void and ineffective, and the same is in violation of Section 42 of the Rajasthan Tenancy Act 1955 and Section 13 of the Rajasthan Colonization Act 1954. The said suit came to be decreed. Feeling agreed with the judgment and ordered passed by the trial court, the appellant, the original defendant, filed appeal before the Revenue Appellate Tribunal, which dismissed the said appeal. The appellant, the original defendant, filed the appeal before the Board of Revenue, which came to be allowed by giving benefit of compounding to the appellant, the original defendant, on payment of compounding fees under Section 13 of the Rajasthan Colonization Act 1954. The writ petition filed by the respondent, the original plaintiff, dismissed by a single judge. On appeal, the division bench set aside the judgment and order passed by the single judge, holding that the appellant herein, the original defendant, being the resident and scheduled caste belonging to state of Punjab, he could not have taken the benefit of his being scheduled caste in the state of Rajasthan. Being aggrieved, the appellant, the original defendant, purchaser of the land in question, has preferred the present appeal. The short question which is posed for consideration is whether the land transaction in favor of the appellant, the original defendant, was illegal and in violation of Section 42 of the Rajasthan Tenancy Act 1955 and Section 13 of the Rajasthan Colonization Act 1954, being a person belonging to scheduled caste of state of Punjab. The Supreme Court has held that it is to be noted that in Bainama his address is shown as Village Burajwala, Tahsil Fazilka, District Firozpur, Punjab. In the mutation record also his address is shown as that of Punjab. In the cross-examination he has admitted that he was a resident of Punjab. Merely because his grandfather and father had purchased the agricultural lands in the state of Rajasthan, the appellant cannot be said to be an ordinary resident of Rajasthan. As per Section 42 of Rajasthan Tenancy Act 1955, there is a restriction on sale, gift or bequest by a member of scheduled caste in a favor of a person who is not a member of scheduled caste. Looking to the object and purpose of such a provision, it can be said that the said provision is to protect a member of the scheduled caste belonging to the very state he belongs, that is, in the present case, the state of Rajasthan. The appellant, the original defendant, being a scheduled caste belonging to a state of Punjab and being ordinarily and permanent resident of state of Punjab, cannot claim the benefit of a scheduled caste in the state of Rajasthan for the purpose of purchase of the land belonging to a scheduled caste person of state of Rajasthan, which was given to original allottee as scheduled caste landless person and therefore as rightly held by the division bench of the High Court. The sale transaction in favor of the appellant, the original defendant, was in clear breach and or in violation of Section 42 of Rajasthan Tenancy Act 1955. It is required to be noted that when the Board of Revenue granted the benefit of compounding under Section 13A2, an order of ejection of appellant, the original defendant, was already passed against him and Puran Singh, and the possession was already handed over to the respondent, the original plaintiff, from Puran Singh, who was found to be in actual physical possession of the land. Section 13A2 of the Rajasthan Colonization Act 1954 would be applicable only in a case where an order of ejectment has been passed, but a person against whom an order of ejectment has been passed has not actually been ejected from the land transferred. In that view of the matter, no order of compounding in favor of the appellant, the original defendant, and or even Puran Singh could have been passed by the Board of Revenue in exercise of power under Section 13A2 of the Rajasthan Colonization Act 1954, and therefore also the order passed by the Board of Revenue confirmed by single judge permitting compounding was contrary to Section 13A2 of the Rajasthan Colonization Act 1954, and therefore also the land transaction question is hit by Section 13 of the Rajasthan Colonization Act 1954. Thus, the land transaction in favor of the appellant, the original defendant, was in breach of Section 13 of the Rajasthan Colonization Act 1954 and Section 42 of the Rajasthan Tenancy Act 1955, which is rightly held to be void by the division bench of the High Court. Coming to the next important judgment titled Rajasthan Marudhara Gramin Bank versus Ramesh, Chandra, Meena and another, pronounced on 4th January 2022. This judgment deals with that there is no absolute right in favor of delinquent employee to be represented in department proceedings through the agent of his choice, and the same can be restricted by the employer. The facts of the case would be that the respondent, the original writ petitioner, was working as cashier cum clerk. While working as a branch manager, is alleged to have committed certain irregularities amounting to misconduct. A departmental inquiry was initiated against him. A charge sheet was served upon the original writ petitioner by the bank in terms of Rajasthan Marudhara Gramin Bank Officers and Employees Service Regulation 2010. An opportunity was afforded to the original writ petitioner to take assistance of a defense representative in accordance with Regulation 2010, as also in accordance with guidelines issued by the bank. However, the original writ petitioner informed the inquiry officer that he may be allowed to defend himself in the inquiry through a legal practitioner. Keeping in view the restrictions under Regulation 44 of the Regulation 2010 on engagement of legal practitioner during the inquiry, his request permitting him to defend himself through a legal practitioner came to be declined. Being aggrieved, the employee filed writ petition praying that he may be permitted to engage any legal practitioner or retired officer of the bank as his defense representative. The single judge allowed the said writ petition and directed the bank to permit the original writ petitioner to be represented through retired officer of the bank in the disciplinary proceedings. On appeal, division bench held that since a circular in question and the regulation 8.2 did not prohibit the utilization of the services of ex-employee of the bank, therefore judgment and order passed by the single judge is not to be interfered with. Being aggrieved, the bank has preferred present appeal. The short question which is posed for consideration is whether the respondent employee as a matter of right is entitled to avail services of an ex-employee of the bank as his defense representative in the departmental proceedings. The Supreme Court has held that respondent employee has no absolute right to avail the services by ex-employee of the bank as his defense representative in the departmental proceedings. It is true that Regulation 44 puts specific restriction on engagement of a legal practitioner, and it provides that for the purpose of an inquiry under Regulation 2010, the officer or employee shall not engage a legal practitioner without prior permission of the competent authority. Therefore, even availing the services of legal practitioner is permissible with the leave of the competent authority. However, regulation does not specifically provide that an employee can avail the services of any outsider and or ex-employee of the bank as defense representative. Therefore, Regulation 2010 neither restricts nor permits availing the services of any outsider and or ex-employee of the bank as defense representative, and to that extent regulation is silent. If the reasoning of the High Court is considered, it is difficult to accept that a retired employee of the bank cannot be engaged to represent a delinquent officer in the departmental inquiry. However, the High Court has not appreciated the effect of the handbook. The Clause 8 of the handbook procedure specifically provides that defense representative should be a serving official from the bank. The said handbook procedure, which has been approved by the board of the directors of the bank, is binding to all the employees of the bank. Handbook procedure can be said to be supplementary. The same cannot be said to be in conflict with Regulation 44 of Regulation 2010. Neither Regulation 44 permits nor restricts engagement of an ex-employee of the bank to be defense representative. Therefore, Class 8.2 cannot be said to be in conflict with the provisions of Regulation 2010. Provisions of Regulation 2010 and the provisions of handbook procedure are required to be read harmoniously. The result can be achieved without any violation of any of the provisions of Regulation 2010 and the handbook procedure. There is no absolute right in favor of the delinquent officers to be represented in the departmental proceedings through the agent of his choice, and the same can be restricted by the employer. The bank has justified its action of not permitting ex-employee of the bank as defense representative. Not permitting the delinquent officer to be represented through ex-employee of the bank in the departmental inquiry cannot be said to be in any way in breach of principles of natural justice and or it violates any of the rights of the delinquent officer. The only requirement is that delinquent officer must be given fair opportunity to represent his case, and that there is no absolute right in his favor to be represented through the agent of his choice. The employee, as a matter of right, cannot pray that he may be permitted to represent through the agent of his choice. The High Court has committed an error in permitting respondent delinquent officer to be represented in the departmental inquiry through ex-employee of the bank. The view taken by the learned single judge confirmed by the division bench is unsustainable. The impugned judgment and order passed by the single judge confirmed by the division bench permitting the respondent delinquent officer to be represented in the departmental proceedings through ex-employee of the bank is hereby quashed and set aside. Now we are going to deal with the important judgment titled JASDEEP Singh alias JASSU versus State of Punjab, pronounced on 7th January 2022. The judgment deals with that mere common intention per se may not attract Section 34 of IPC without an action in furtherance. The facts of the case would be that, along with other accused, the appellants, who are accused numbers 3 and 4, were convicted under Section 304 Part 1 of IPC with life sentence. On appeals, the High Court concurred with the views of the trial court. Being aggrieved, the accused numbers 3 and 4 are before Supreme Court with the allegation that mere statement per se would not be sufficient to attract Section 34 of IPC, and thus the courts have committed an error in applying Section 34 of IPC. The senior counsel appearing for the de facto complainant submitted that it is not necessary that an accused will have to do a physical act in order to attract Section 34 of IPC. Thus, a mere presence of the accused would suffice. The Supreme Court has held that the phrase in furtherance of the common intention was added in the statute book subsequently. It was first coined by Chief Justice Barnes Peacock presiding over a bench of Calcutta High Court while delivering its decision in Queen versus Korachand Court, which would have probably inspired and hastened the amendment to Section 34 of IPC. Section 33 of IPC brings into its fold a series of acts as that of a single one. Therefore, in order to attract Section 34 to 39 of IPC, a series of acts done by several persons would be related to a single act which constitutes a criminal offence. A similar meaning is also given to the word omission, meaning thereby a series of omissions would also mean a single omission. This provision would thus make it clear that an act would mean and include other acts along with it. Section 34 of IPC creates a deeming fiction by infusing and importing a criminal act constituting an offence committed by one into others in pursuance to a common intention. Onus is on the prosecution to prove the common intention to the satisfaction of the court. When a part of evidence produced by the prosecution to bring the accused within the fold of Section 34 of IPC is disbelieved, the remaining part will have to be examined with adequate care and caution. As we are dealing with a case of vicarious liability fashioned on the accused by treating him at par with the one who actually committed the offence, what is required is the proof of common intention. Thus, there may be an offence without common intention, in which case Section 34 of IPC does not get attracted. The intent of Section 34 of IPC is to remove the difficulties in distinguishing the acts of individual members of a party acting in furtherance of a common intention. There has to be a simultaneous conscious mind of the persons participating in the criminal action of bringing about a particular result. Normally, in an offence committed physically, the presence of an accused charged under Section 34 of IPC is required, especially in a case where the act attributed to the accused is one of instigation or exhortation. However, there are exceptions, in particular when an offence consists of diverse acts done at different times and places. Therefore, it has to be seen on a case-to-case basis. The word furtherance indicates the existence of aid or assistance in producing an effect in future. Thus, it has to be construed as an advancement or promotion. There may be cases where all acts in general would not come under the purview of Section 34 of IPC, but only those done in furtherance of common intention having adequate connectivity. When we speak of intention, it has to be one of criminality with adequacy of knowledge of any existing fact necessary for the proposed offence. Such an intention is meant to assist, encourage, promote, and facilitate the commission of crime with the requisite knowledge as aforesaid. The existence of common intention is obviously the duty of the prosecution to prove. However, a court has to analyze and assess the evidence before implicating a person under Section 34 of IPC. A mere common intention per se may not attract Section 34 of IPC sans an action in furtherance. There may also be cases where a person, despite being an active participant in forming a common intention to commit a crime, may actually withdraw from it later. Of course, this is also one of the facts for the consideration of the court. The trial court, which had the advantage of noting the deposition of the witnesses, chose to disbelieve the evidence adduced by giving cogent reasons. This evidence was rightly eschewed by the trial court and also by the High Court. There is no evidence at all on record to hold that accused 3 and 4 were aware of the fact that accused 1 was having a gun with him. The prosecution wanted to implicate accused 3 and 4 mainly on the evidence of PW 13. Once the said evidence was not accepted, more care ought to have been taken before convicting accused 3 and 4 under Section 34 of IPC. A common intention can be formed at the time of the occurrence. However, the evidence available is not sufficient enough to hold that Section 34 of IPC is attracted against accused 3 and 4, especially when the testimony of PW 13 did not find favor with the courts. Except the statements said to have been made by accused 3 and 4, there was no other material to implicate them. The prosecution has not proved its case beyond a reasonable doubt as against accused 3 and 4 by reflecting the offence committed by accused 1 taking umbrage under section 34 of IPC.